Eagle from Burlington and Rockenbach, here on behalf of the plaintiff, Corin Steel. I'd like to reserve 5 minutes of my time for rebuttal. The appellant's husband died when a water tank propped 30 to 40 feet in the air and filled with 300,000 gallons of water collapsed on the building that Mr. Steel was working in. The appellee below, George Twigs, is the person who filled the tank the day before it collapsed. The issue here is whether Mr. Twigs had a duty to Mr. Steel. We believe that the answer is yes, and that the trial court erred in entering summary judgment in favor of the appellees, who were Mr. Twigs and his employer, Amtrak. Now, as you all know, duty is a...
Can I make sure I've got the players lined up correctly?
Yes.
There was an entity called United Fire.
Yes, that is Mr. Steele's employer.
Okay, and they were hired to perform the repairs on the
pumps.
The pumps.
Yes. And
then Mr. Twigs worked for who?
He worked for Amtrak. I think he was an independently owned company.
And were they retained by United Fire?
Yes.
Okay, so Mr. Twigs is an electrician.
Mm-hmm. Yes,
and he works for a company that's retained by the company that's retained to do the repairs.
Yes, that is it.
All right.
Does that answer the questions as far as the players?
Right.
All right. So the issue here is whether there was a duty on the part of Mr. Twigs to Mr. Steele.
And if I read the record correctly, there's no indication that Mr. Twigs knew there was any problem with the water tank.
No, and that's part of our claim here, is that he had no knowledge of the condition of the tank itself, and basically he shouldn't have filled it, and I'll get into that more, but...
Well, he didn't fill, he turned on the switch at the direction of the owner?
Yes, which then filled it.
Right.
So he was the one who filled the tank.
Sort of. Anyway, go ahead.
Okay, so a duty exists where a defendant's conduct creates a foreseeable zone of risk to anybody in the area. Here, filling this tank that was propped up 30 to 40 feet in the air with 300,000 gallons of water created a zone of risk to anybody in the area. Now that gave rise to a duty on the part of Mr. Twigs to make sure that to either eliminate the risk or lessen the risk. And what we've alleged here is that he had a duty to either, under these circumstances and the facts of this specific case, to either not fill the tank at all or to ensure that the tank could hold the water before he filled it up, which he did not do. That alone, I mean, that was the duty. You've got this huge tank of water up above the air that he filled with 300,000 gallons of water, and that established the duty on his part to make sure that it could actually hold the water. Defendants' arguments, they raised several arguments below and several arguments here, which are generally, I believe, to be red herrings with regard to the specific issue here. They're either not legally relevant at all, I believe, or not relevant to the specific issue of duty, which is a minimum requirement to just get the case into the courthouse. One of their arguments here was that they did not create a broader zone of risk than what already existed due to the condition of the tank. That is a completely misplaced argument, because here there was no allegation, no claim, no facts to establish this tank empty was any harm to anybody. It certainly was not any harm to Mr. Steele on April 7th. Maybe down the line it could have started falling apart because it was rusted, but on this day, on April 7th, when Mr. Steele was there with his coworker working, there's no allegations or facts that this empty tank would have caused any harm to Mr. Steele. Another argument that they raise is that, and I think that this is one of the things that you were implying, Judge Black, is that the owner, the owner wanted this turned on. The owner wanted the tank filled. Everybody, according to defendants, everybody wanted the tank filled for this fire inspection the next day. Legally, as far as Mr. Twigs' duty, whether anybody wanted it filled or not is not relevant. What is relevant is whether the tank could hold the water, and whoever filled it had a duty to make sure that the tank actually could hold the water. If Mr. Brusso had turned on the switch himself and filled the tank, the duty would have then been on him, but he didn't do it. And the testimony was very clear from Mr. Twigs that nobody else could do it. This tank probably, from the evidence in the record, may not have ever been filled that day if Mr. Twigs had not done it himself. He testified that the control panel to turn on the pump which filled the tank was in such a state of disrepair that there were two separate switches, one a button I think that could start it, and then also a lever that could start it. Neither one of those worked. He had to open a control panel and manipulate some electrical, things, for lack of the technical terms, in order to get this pump on to fill up the tank with water. And he testified himself that it wouldn't have been safe for anybody else to do this. He said that this system inside the control panel was not in a safe, operable condition, not safe to be operated. Now, we're not arguing that this was any sort of electrical thing issue, obviously. But the point of that is that this...
I guess I'll go back to, what Judge Black was alluding to. The decedent has no specific knowledge about the tank and its ability to hold water or not. Doesn't know if it's safe or not. Doesn't know if it was inspected, was it maintained, was it repaired. There are other people that have that knowledge. Presumably the owner has that knowledge. The owner says, you've come out to repair the electricity. I can't figure out how to turn it on. So is the duty that you suggest the other side has, I'm trying to really grab a handle on it, because at what point does the electrician say, oh, I need to make sure that it's really okay, or you need to tell me more? Does your decedent have the obligation to inquire, or as the electrician, can he just say, boss man is telling me to turn it on, I'm turning it on?
I have a couple of points to that. The first...
I don't know, I'm mixing up characters.
No, I understand, but I think that the first and most important thing is I think that goes to whether he breached his duty. I think that because the duty is to make sure that the
decedent has maybe not the best information, but he is involved in the water tank aspect of all this.
He is not actually involved with, as far as he was switching out the pumps.
Okay.
There's no...
The pumps that feed into
the
the
pumps
water
that
tank.
feed into the different water tanks.
And so he may or may not know whether the tank should be holding water or not.
Exactly. And again...
But the electrician is there for a specific task. And so I guess I'm trying to figure out the duty you're suggesting is that the electrician had to either inquire more or should have refused, say, well, prove to me that you've maintained it properly and it's not going to crash, but he doesn't know anything about the tank.
And that's the point, Your Honor. I think it goes to what you're saying is that he wasn't there to... This has nothing to do with why he was there specifically, to the extent that he was an electrician, and we haven't argued that he was negligent in his electric work. If I walked up to a water tank and I have no relationship to anything, and I see a big green start button and I press it and I have no clue whether it can hold water, and something happens, that's on me. The issue of why I was there, if someone just walks up with absolutely no knowledge, and this is, I think, very, it's safe to say that this is sort of a dangerous situation, potentially. You've got this huge tank, it's up above the ground.
Aren't you imposing a duty on the electrician to then basically do a full systems inspection, which he's not really qualified to do?
No. What we're imposing for him is to not fill it at all.
But the owner, somebody has retained a company to come and do a repair to the water tank system as a whole. But as a preliminary step in order to do this, they need the electrical guy. I think this is kind of the same thing Judge Silverman's asking. Why did, United Fire is supposed to be doing this repair, but until they can't really even get at the repair until somebody throws the switch. The electrical guy is hired to throw the switch.
He was not hired to throw that switch. He was hired to replace to disconnect and connect.
Well, the owner, he's on site. The owner himself is saying, by the way, I think there was something in the record, he went back to get his lunch bucket, or he went back for something. Yes. I forget what it was, but for some reason he had occasion to go back on site. Oh, by the way, while you're here, we need to test this water system, so before we can do that, could you throw the switch for me? And the guy says, yeah, I can do that. If he was on notice that there was a problem, that seems to me a different scenario than he's an electrical guy, the owner's got him there with an electrical need. I'm having a hard time seeing it.
And again, it goes back to what I was starting to say before, that is an issue of whether he breached his duty.
But
If-
first you gotta find a duty.
And
How far down does it extend?
What do you mean by how
The
far
duty.
down? The duty extends to just finding out whether,
Suppose the electrical
Asking
guy says,
somebody.
you know, I don't really know how to do this, but the guy, I was talking about this system with the guy who's mowing the yard over there, and he knows how to do it. Let's get him to do it.
then the guy mowing the
Then he
yard
has the
would have a duty to find out whether or not this, should be operated. This is a dangerous, whole system. Mr. Twigs recognized that. He recognized that the fire marshal had to be there to do certain aspects of this. He knows that this isn't just, this whole system is a very complicated and dangerous system. He knows that there are people and they're assigned to do different roles.
So he should have,
to get back,
in your view, you should have just said, no, I'm sorry, I can't do that, I won't do that.
I'm going to throw this out there because I think it goes to what both of you are saying. First, there's no evidence that he actually asked Mr. Brusso, the owner, whether or not this was, the tank could hold the water. But for the purposes of this discussion, let's say we could assume that by Mr. Brusso asking him to turn on the switch and fill up the tank, it could be reasonably assumed that Mr. Brusso was at least of the belief that this tank could hold the water.
Let's hope so.
I would hope. But again, whether the owner of the property has any actual knowledge of whether this tank can hold the water is not something that I think we can assume, first of all, when he's hired specialists to deal with the replacement and the repairs. But for the purposes of this, if we can assume that Mr. Brusso or Mr. Twigs had asked and Mr. Brusso did say, yes, as far as I know, this was, according to, people that I've hired, they've said it's safe, so let's go ahead and turn it on. Or we could assume that that was the implication by the fact that he asked Mr. Twigs to turn it on. That goes to the breach. That goes to whether it was reasonable for Mr. Twigs at that point to go ahead and turn it on and fill up the water, not to whether he had a duty. And that's for a jury to determine whether that was reasonable for him to trust Mr. Brusso and trust his knowledge and say, that was enough. Under these circumstances, the guy says, hey, can you turn this on? And in the situation as a whole, as you've mentioned, he's hired these people to run it. As they've said, the whole purpose was to test this whole system. Maybe that would be enough. But that's for a jury to decide whether or not he fulfilled his duty. And his duty was to make sure that this water tank could hold the water or to not turn it on at all because he had no knowledge.
How did he get that duty? What
duty
gave rise to that duty?
The duty arose for when he filled the tank.
No, what gave, specifically, you're saying his duty was to make sure this tank was safe.
Correct.
Okay, what gave rise to that duty?
The foreseeable zone of risk created by a full tank that's propped up 30 to 40 feet in the
How
air.
did he create that risk?
He filled it with water. It was empty, and as
No,
far as
the risk was that you're saying that the problem was that the tank wasn't safe, that it hadn't been maintained. Okay, he didn't create that risk.
it could have stood up there for 20 more years empty for all we know. There are no facts as to that. The problem and the risk to Mr. Steel on April 7th, 2011 was when it was filled. That tank, as far as we know, was no risk to anyone sitting there empty. It became a risk when it was filled with water and it was not in a condition to hold the water.
So I guess if somebody else had turned it on, you'd be arguing that he created the risk because he repaired the electric system, allowing it to be turned on. Would that be your argument then?
No, he didn't actually repair the electrical system for the ground well pump, but I think that would be probably not as foreseeable. I mean, this is you could argue it's not foreseeable because it's 10 steps down the line.
Well, it's foreseeable if they're repairing the pumps that it's because they want to turn them on. So anybody that had any involvement in repairing those pumps, they had a duty to make sure that tank was okay? Because it was foreseeable somebody was going to fill it?
It is foreseeable that this could create a danger and that you should ensure, the duty is to ensure that the duty that we've alleged first was for him.
How long did it take to fill that tank?
We don't know exactly how much water went into it, or even if it was completely full. I used up to 300,000 in the brief. It was rated to hold 300,000 gallons of water, but we don't know how much it was filled at the point where it was collapsed, or how much water was in it at that point.
You're right at the 15-minute mark,
Okay.
if you wish to reserve the time.
Yes, I'd reserve the rest of my time for rebuttal. Thank you.
May it please the court. My name is Gary Vasquez, and I represent AMP and George Twigs, who's the owner of the business. We believe that the trial court correctly entered final summary judgment in this case because there was no duty and no duty that was breached. I would point out to the court that this suit was filed back in June of 2011, and our motion for summary judgment was heard in September of 2013. So 2 years and 3 months later, after numerous depositions were taken, there was simply no evidence in the record whatsoever to suggest that my client did anything wrong to cause or contribute to the accident, and in fact there was simply no breach. There was no expert testimony that would suggest that we did anything wrong or caused or contributed. There was no testimony from any lay witnesses, and they were all asked, do you think AMCHEC did something wrong in this case? And the answer to all of those questions unequivocally was no. They were there simply to connect a new pump that was being installed by the company that hired my client. My client was an independent contractor hired by United Fire to reconnect the new system that was going to be employed. There were no affidavits in this case suggesting the electrician did something wrong. The argument there.
Well, the argument is what he did wrong was turn the pump on.
Correct. That's the argument, and
Right.
the record will suggest that United Fire was trying to do that. The decedent himself was trying to do that. The owner of the project was trying to do that. For a duty to exist under the law in Florida.
Yeah, but my point was, you're standing here saying there was no allegation that he did anything wrong. Well, yeah, there is. The allegation is what he did wrong was turn on the pump.
Okay, but that is the.
What I think you mean is that he didn't do anything wrong within the scope of what he was retained to do.
True. As I was indicating, the decedent himself tried to start the pump. If there is an inference in this case, it would be that the tank itself is okay to take water on. We don't know how much water was placed in the tank, and I know it's in the record. I believe it was several days it would take to fill the tank. I didn't have a chance to get to it. I was looking for that. But as indicated earlier, the statement was made that my client filled the tank. He did not. He simply turned it on. The owner was present and was going to determine how much water goes into that tank. There's simply no.
I think what you're saying is nobody had a reason to believe that the tank was going to collapse.
Of course.
The decedent himself was trying to do what Twigs ultimately did, because they all wanted to put water in it because they were testing it.
Yes, Your Honor.
So there's no duty because nobody thought this was going to kill people, right?
Exactly. And that was the conclusion that Judge Arnold came to at the end of the hearing. I'll stand by my brief unless y'all have questions.
I think that's it.
All right,
Pretty
thank you.
straightforward, the arguments.
I could just briefly, a couple more things
I
here.
mean, in
Ron.
order for a duty to arise, as Judge Kelly was going to, wouldn't you have to have something that indicated that, you know, Mr. Twigs knew that these tanks were defective? He read a report, he talked to the owner, somebody said, hey, you better not do that because this thing may collapse. To the contrary, everybody wanted him to do what he did to get the water going because that's what everybody wanted to do. Nobody thought it was gonna collapse, right?
You're correct. As far as I know, nobody on this scene knew that was going to happen, because
I mean, I'm sure, I would hope the owner wouldn't tell him to do that knowing or thinking or even remotely thinking that the tank can't hold it. I'm sure the decedent wouldn't be trying to turn it on if he thought that. This caught everybody by surprise. That's the tragedy, right?
It is tragic and it is unfortunate, but what we're saying, the duty was.
Well, what was he supposed to do? The owner wants it on, United
Say no.
Fire wants it on, the decedent wants it on, he's the guy with the skill to do it.
He could, he shouldn't have filled it at all because he wasn't knowledgeable about the system. He had no knowledge, as he admits.
Did he stay there during the time it was filled?
No, he left.
He turns the pump on.
He turns it on and leaves. Mr. Russo and the security guard.
He is there when Mr. Steele and Mr. Martinez are trying to turn it on.
I think the day before, or earlier in the day, he thought he noticed them,
They're
trying to
trying
turn
to
it on.
manipulate the levers and get it to
Yes.
go on, and it won't go on.
And the owner says, look, since you're here, here's $5, turn the electricity on.
Yes. I would present to you that none of that goes to his duty. It was foreseeable that this tank could cause harm, theoretically, whether it be because it collapsed or for any reason. He should have inquired into the safety or into whether this tank could hold the water before he turned it on, and he did not do that. And that was his duty, and any issues of whether he breached his duty,
Why does he have that duty when Mr. Steele, who ends up being the unfortunate victim in all this, but Mr. Steele is trying to get the pump turned on?
But Mr. Steele couldn't turn it on.
But he
Nobody
wants
else
he
turned
wants
it on.
And he's there as the person working on the pump that is going to fill the tank. So I guess my question goes to, how far removed can a person be before, in your scenario, that would not be foreseeable?
I'm not sure if I'm understanding exactly. I mean, I think that there was no removal here. He is the one who turned it on.
You're suggesting there's a duty because it was foreseeable that if he turns on the pump, the tank will be filled and the tank will then collapse.
Something could happen, yes. It
So,
can collapse for
you know,
many reasons possibly.
So if you go up the line, is the utility company who provides the electricity liable because they know they're doing, in theory, I know they're on site as well, so they know that electrical work is being done. Do they have a duty to not provide electricity to this panel until they've confirmed for themselves that the tower is not going to collapse?
No, and because there's too far removed. I mean, I can't draw a line, I would say, as far as.
But aren't we and the trial court drawing the line, or supposed to draw the line as far as a foreseeability analysis?
And to me, this seems so simple because there was no removal here. The tank collapsed because it was filled with water. He's the one who filled it with water. This isn't the electric company who had the electric and then that charges the pumps and the pumps got turned on. This is the guy who filled it with water. The filling of the tank with water is what caused it to collapse. There's no removal here.
Technically, he really didn't fill it. He just turned on the power source.
He turned on.
Whoever stayed around filled it.
He's the one who turned the water switch on. If I turn on my tub and start filling it, I'm the one who filled the tub. If I walk out of the room, I think I'm still. He didn't just turn on the electricity. He actually turned on the water and started it running. So there was no removal here that he is the one who just provided the electricity. He actually, comparing this to a bathtub, turned on the faucet and started the water running without knowing whether it could hold the water. One thing I wanted to address that that was addressed by Appellees was that there were no.
Let's use your scenario for a minute.
Yes.
If I do a remodel in my house and I have a new bathtub installed, and it's a jacuzzi type tub, so there's electric going to it, and the electrician's there hooking up things and so forth, and the electrician comes back the next day and I say, turn on the power. Is it the electrician's responsibility to make certain that the plumber has in fact coupled all the links in the piping so that the water isn't just going to run out and fall through the ceiling or onto the hardwood floor or whatever? An
No.
electrician knows that a new tub is being put in. I ask him to turn on the water the next day. He's there because the pump for the jacuzzi has to be hooked up. Does he have to double check what the plumber is doing or is supposed to do or might do?
I would say the answer to that is no, and that is relative, that is connected to the cases cited by Appellees in their brief, the White case and the Callejas case. In both of those cases, an electric company flipped on the power to a house, and apparently the house, you know, the outlets and whatnot weren't, you know, safe to have power going through them. And one was a dismissal and the other one was a summary judgment, but the gist of these cases said, if it had been alleged or established that the electric company knew or should have known that it was dangerous to do this, and that something was wrong with this house and that there was a danger here, then they would have been liable. And that's what we have here, to the extent that we've alleged.
The owner doesn't have any knowledge, the Steel doesn't have any knowledge. What is he on notice of that there's a defect?
Well, what we alleged and what we established is that he knew that the interior part of it, the part that he knew about, this system, this was all one system, the fire suppression system, was unsafe. There were many code violations. There was no reason for him to, he knew that the system as a whole was not safe. There was nothing in the record to give him any reason to believe that anything else was, you know, that the tank could hold water when the entire operating room and the panels, there were violations, and he said it was unsafe to operate that control panel because of the problems that was the reason why nobody else could start it, and he had to go in manually.
We've gotten a lot of questions on your rebuttal, so I've let you go over, but you need to sort of wrap it up.
Thank you, I appreciate that. I would just ask that you reverse the final judgment and remand the case back to the trial court to proceed with trial. Thank you.
Thank you very much. That concludes this. We are adjourned.